Hello, criminal trial process class. I am doing lecture 2 video. I think I've got the technology figured out. Here we go. That's better. So, lecture 2 is about the Constitution and the Bill of Rights. To start us off, our sources of American law overview. We have the Constitution, which creates our government. We have legislators, also called lawmakers, who literally create our laws. The acts of legislators, though, are not necessarily law. Just because the legislation passes a bill doesn't mean the bill is a law. Our U.S. Congress may not lawfully pass legislation that surpasses our Constitution and the Bill of Rights. Our Constitution was established in 1787. We had 13 state delegates that met in Philadelphia to write a new constitution, which outlined the powers and limits of the federal government. This is after we had the Revolutionary War against England to become free of England and establish our own country. And then we established our constitution. There are only 3 individual rights mentioned, which is in the Constitution: habeas corpus, illegal detention; bills of attainder, punishment without trial; and prohibition of ex post facto laws, which is legislation making prior conduct criminal. However, we had amendments to our Constitution, and these are called our Bill of Rights. They are the first 10 amendments to the Constitution, although I'm going to hit on 14 amendments, but the Bill of Rights are the first 10 amendments, and within them, there are 23 individual rights in the Bill of Rights, which amends our Constitution. In order to understand our individual rights and criminal procedures, the Bill of Rights needs to be examined. So this is a good foundational lecture for this course. And we'll just go through them numerically. The First Amendment, we all know about that. It has a lot to it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise or abridging the freedom of speech or of the press or the right of the people to assemble peacefully and to petition the government for a redress of grievances. In other words, one part of it is freedom of religion. Government is barred from interfering with individuals' religious practices. The federal government is not supposed to promote a particular religion or to prevent the practice of religion. The freedom of speech is a huge part of the First Amendment also. Verbal, written, and some physical expressions are included in our freedom of speech. And we have the freedom to peacefully assemble, to also protest peacefully. The Second Amendment, it's kind of short. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, so that's pretty broad. So opponents of gun control legislation, so those who do not want gun control laws, states that this prevents the state from enacting legislation that restricts in any manner the use and possession of firearms. In other words, there should not be any restriction at all in the use and manner of firearms. That's one debate. The supporters of gun control legislation argue this amendment was not intended to create an individual right to possess firearms, but the intent is to create a right for groups of citizens who want to form a militia to have a firearms to protect themselves against oppression of the federal government. So those are 2 pretty extreme polar spectrum views, of the Second Amendment. And there's a lot of debate on this. And actually, maybe we'll have a discussion on this because on the different aspects of it, of the Second Amendment. So there was but something to think about with the Second Amendment. There's a lot of concern, great concern at the time of this amendment that the federal government might become oppressive because we had just broken away from England and the King of England, and they were allowing, we were allowing people to form militias that because we didn't want the federal government to take over and to outlaw weapons. So I'm sorry, I read that kind of fast. The King of England and allowing people to form militias would not be of much use if the federal government outlawed weapons. So in other words, if you take our weapons away, we can't fight an oppressive government. And that is really what it's about. Okay, more debate on that to come. The Third Amendment, no soldiers, and there's a typo there, shall in any time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So back to the American Revolutionary War, where we were fighting against England to get our freedom and to have our own country. The English troops were housed in the homes of American citizens against the wishes of the homeowner. So that's how this Third Amendment was established. It prohibited quartering or housing of soldiers in private homes without the permission of the homeowner during times of peace. The Fourth Amendment is one that you hear about a lot in our criminal justice classes. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be searched. It's kind of written confusingly, but what this means is that it forbids unreasonable searches and seizures by law enforcement and requires the existence of probable cause before an arrest and a search warrant is needed or may be issued. Probable cause is fair probability more than 50% that a crime occurred. Proof beyond a reasonable doubt is close to 99%. That is when we have a jury trial to determine if someone is guilty. We dive into that in criminal evidence. The Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless on presentation or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life, of limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without compensation. That is a lot. And what it says is there cannot be an indictment, you have the right to indictment by a grand jury. And we talk about indictments in the grand jury quite a bit in criminal evidence, but we'll dive a little bit more in this class about that as well. You are not allowed to be charged twice for a crime. If you were found acquitted, you were found not guilty in a crime, you can't be charged again. So that has to do with double jeopardy, prohibition of double jeopardy. The right to due process of law. I'm sorry, I said prohibition of double jeopardy. Sorry, I'm really tired. I can't talk. Right to due process of law, and then privilege against self-incrimination. You don't have to testify against yourself. Okay, I'm spitting this out. Here we go. Sixth Amendment. This is one that also is common in our criminal justice classes. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state, and the district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him or her, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Okay, so this is, you have the right to a speedy trial, you have the right to a public trial, you have the right to an impartial jury, you have the right to be notified of the charges against you, and you have the right to an attorney to be represented by counsel. You also have the right to a trial in which you can confront people who are accusing you of a crime. That's confrontation of witnesses. Seventh Amendment, in suits at common law where the value in controversy shall exceed $20, the right of the trial by jury shall be preserved, and no fact tried by jury shall be otherwise reexamined in any court of the United States than according to the rules of the common law. This had to do with civil lawsuits, federal only, and the right to trial by jury. Probably not even worth mentioning. The Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. This prohibits or bars the state from imposing excessive bail. It bars the state from cruel and unusual punishment. Okay, what does that mean? So there's, you can dive deeper into and debate on what that means. But also bail, and I shouldn't have skipped ahead yet. Let me go back really quick. So we have an issue going on right now in some states where they don't have bail, and somebody commits a violent crime and then they're just released in their own recognizance until they're trial date, and then they commit more crimes. So this is a pretty good debate subject to have. So maybe this is another discussion to have that we should have in our classes. Okay, this is a pretty broad amendment, but does that mean we just let people out without bail if they committed a violent crime? So this is something that, and what does cruel and unusual punishment mean as well? So there's some debate on this amendment. The Ninth Amendment, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The listing of individual rights in the Constitution should not be construed as the listing of the only rights restrained by citizens. In other words, our founding forefathers were saying, hey, just because we wrote all these bills of rights doesn't mean that's the only rights we have. We have more. So I think the Ninth Amendment just kind of encompasses like we have more rights than just that. It's really, as you can tell, our Constitution and the Bill of Rights was written by some men who were quite paranoid of the federal government. And they should have been. And maybe we still should be, right? That we don't want them to control us. The Bill of Rights are only some of the rights of the citizens. We have more than just what the Bill of Rights listed. And that's basically what that says. The 10th Amendment, the powers not delegated to the United States by the Constitution nor prohibited by the states are reserved to the states respectively or to the people. That means the rights not delegated to the federal government are reserved for the states or individual citizens. Again, the federal government has no authority to act unless so granted by the Constitution. The states and the individual citizens retain authority. This is another amendment saying back off federal government, and pretty important. 11th Amendment, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subject of any foreign state. Well, this one's kind of confusing. Basically, what it says is it prohibits the federal government from hearing certain lawsuits against states. Okay, that one we probably don't even need to talk about. The 12th Amendment outlines the procedure of how presidents and vice presidents are elected, how they are elected. The 13th Amendment abolishes slavery, neither slavery nor involuntary servitude, except as punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or place subject to their jurisdiction. This amendment abolished slavery. The 14th Amendment is the last one that we're covering. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any persons of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws, i.e., persons born in the United States are citizens of the United States. States cannot deny citizens of their due process of law. That is the end of our lecture 2. Very important, our Bill of Rights.